You're at home. There's a knock at the door. You look through the peephole. Federal agents. ICE badges. Your heart stops. And what you say in the next 30 seconds will determine everything. Every day across America, people open their doors, answer questions, and hand over documents they were never required to give. They think cooperation protects them. They think being helpful makes the agents leave faster. But the law doesn't reward people who talk. It rewards people who know exactly what to say and exactly when to stop. I've spent years analyzing immigration enforcement law and studying federal court rulings. I've identified 5 legally grounded phrases that stop an ICE encounter cold and force agents to either produce legal authority or leave. Miss one of these phrases, and you may accidentally hand federal agents permission to enter your home, question you, and detain you. Use all 5, and you protect yourself under the United States Constitution. Let's break down the 5 critical mistakes people make and the 5 exact phrases that every person in America needs to know. This is educational content only. It is not legal advice. For guidance specific to your situation, consult a qualified immigration attorney. Mistake 1. Opening the door. The mistake. ICE agents knock. You open the door. That one action just gave federal agents more legal power than they had 10 seconds ago. The scenario. It's early morning. 2 agents in plain clothes stand outside. One holds up a badge. ICE, open up. You open the door because it feels rude not to. Because they have badges. Because you assume you have no choice. But here's what just happened legally. By opening that door and stepping aside, courts can interpret your actions as granting consent to enter. And once agents are inside your home, the legal dynamics shift dramatically. Why people do it. People assume federal agents with badges have the legal authority to enter. That assumption is wrong, and it's one of the most consequential legal mistakes you can make. The legal reality. The 4th Amendment to the United States Constitution protects the right of all people in this country against unreasonable searches and seizures. The Supreme Court has repeatedly affirmed this. In Payton v. New York, decided in 1980, the court ruled that in the absence of exigent circumstances, officers may not enter a home without a warrant signed by a judge. Immigration enforcement is not automatically an exception. The Nonpartisan Congressional Research Service stated in a 2021 report that an administrative warrant, the kind ICE carries, does not confer authority to enter a home or private area. An administrative warrant, such as ICE's Form I-200 or Form I-205, is signed by an immigration officer, not a judge. It is a civil document authorizing arrest for alleged immigration violations. It is not a judicial search warrant. It cannot compel you to open your door. The evidence problem. If you open the door without asking questions, there is no record that agents lacked legal authority to enter. The encounter looks consensual. You have no grounds to challenge it later. The correct move. Do not open the door. Speak through it. And say this, the first phrase. Do you have a judicial warrant? Say it clearly. Say it through the door without opening it. A judicial warrant is one signed by a federal judge, not an ICE supervisor. It will name the specific person, the specific address, and the specific date. Ask them to slide it under the door or hold it up to a window. If they cannot produce one, you have no legal obligation to open that door. Why it works. This forces agents to state their legal authority on record. If they have a judicial warrant, they will tell you. If they only have an administrative warrant, they cannot compel entry. The Federal Law Enforcement Training Center, the government's own training body, has stated in its official materials that an ICE officer who does not obtain consent to enter must wait until the subject is located outside the home. Your closed door is your constitutional shield. Bottom line, never open the door without first asking whether agents have a judicial warrant signed by a federal judge. Mistake 2. Answering questions about your status. The mistake? The agents are at your door or have encountered you in public. They ask, are you a citizen? Where were you born? Do you have papers? Most people answer because silence feels incriminating. But answering those questions may be the most consequential mistake of the entire encounter. The scenario. You're walking to your car. An agent steps up. Hey, can I talk to you for a second? You stop. Where are you from originally? You answer. Are you here legally? You answer again. You have now voluntarily provided statements about your immigration status to a federal enforcement officer. Everything you said is usable. There is no going back. Why people do it? People believe honest answers protect them. They think transparency ends the encounter quickly. They think silence looks guilty. But federal agents are investigators, gathering evidence. Their questions are tactical. The ACLU has documented that ICE agents often make arrests after asking just a few questions about status and origin. The legal reality. The Fifth Amendment to the United States Constitution protects every person on U.S. soil from being compelled to be a witness against themselves. In Zadvitas v. Davis, decided by the Supreme Court in 2001, the court affirmed that the Due Process Clause applies to all persons within the United States, including undocumented immigrants, whether their presence is lawful, unlawful, temporary, or permanent. You are a person. The Constitution covers persons. You have the right to remain silent. Importantly, the Supreme Court ruled in Salinas v. Texas in 2013 that remaining silent passively is not enough. To protect yourself, you must actively invoke your right. Silence alone can be used against you in certain contexts. You must say the words. The evidence problem. If you answer questions about your status, and that information later contradicts other evidence, you've handed the government a prior inconsistent statement. If you answer correctly, you've confirmed the factual basis for detention or removal proceedings. Either way, speaking puts you at a disadvantage. The correct move. Look at the agent, stay calm, and say the second phrase. I'm exercising my right to remain silent. Say it clearly. Don't add anything. Don't explain why. Don't apologize. This phrase explicitly invokes your Fifth Amendment protection, which is exactly what Salinas v. Texas requires. After saying it, stop talking about your status entirely. Why it works. Once you've stated this explicitly, agents cannot later argue in immigration court that your silence was evasion. You've created a record that you asserted a constitutional right. Exercising a constitutional right cannot legally be treated as evidence of guilt. Bottom line, never answer questions about your immigration status, your origin, or your documentation without first invoking your right to remain silent. Mistake 3. Consenting to a search. The mistake. The agents are in your building lobby or at your door. Mind if we take a look around? Most people say yes because they fear looking guilty by saying no. That one word, yes, just eliminated a constitutional protection that took centuries to establish. The scenario. Agents have encountered you. They've asked questions, and you've invoked your rights. Now, one says, "We just want to look through your apartment real quick. Won't take long." You say, "Okay." Agents walk in. They search. They find documents, phones, paperwork. All of it is usable because you consented. You handed them permission they did not legally have. Why people do it. People think refusing makes them look like they're hiding something. They think the agents will get in anyway. They think compliance ends things faster. But here is the legal truth. When an agent asks for consent, it is because they do not have the legal authority to search without it. If they had probable cause and a judicial warrant, they would not be asking. They would already be searching. The legal reality. The Fourth Amendment protects all persons against unreasonable searches. Under Schneckloth v. Bustamante, 1973, voluntary consent legally eliminates the warrant requirement. The moment you say yes, the search is constitutionally authorized. You cannot challenge it later. An administrative warrant does not grant search authority. A judicial search warrant does. If agents don't have one, your consent is the only way they get inside. The evidence problem. Any document, any device, any item discovered during a consented search is admissible in immigration proceedings and potentially in criminal ones. There is no suppression available after voluntary consent. The correct move. Calmly and clearly say the third phrase. I do not consent to this search. Say it loud enough to be heard clearly. Repeat it if necessary. Do not physically interfere with agents. That creates separate legal problems. But say the words on record every time. Why it works. This puts the constitutional burden back on the agents. Without your consent, they must produce a judicial search warrant specifying the location to be searched. If they search anyway after you've refused, your attorney can challenge the legality of everything they found. The record shows you withheld consent. That is a legally meaningful fact. Bottom line, never consent to a search under any circumstances. The correct answer always is, I do not consent to this search. Mistake 4. Not asking if you are free to leave. The mistake. Agents are talking to you in public, outside your apartment, on a sidewalk, in a parking lot. The questioning seems like it's wrapping up, but the agent doesn't walk away. He keeps asking questions. You keep answering. You don't know if you can leave, so you just stand there. Every extra second you wait without asking extends the encounter voluntarily. The scenario. An agent stopped you outside a grocery store. He asked questions. You invoked your right to remain silent. You refused consent to search. He hands back your ID, but then, just one more question. How long have you been at your current address? You answer. Then another question. 15 minutes have passed. You helped build a case against yourself because you never asked the one question that would have forced legal clarity. Why people do it? People assume the encounter continues until the agent decides it's over. They don't realize they may be free to leave. They fear that asking will escalate things, but that fear is exactly what agents count on. The legal reality. Under Terry v. Ohio, decided by the Supreme Court in 1968, officers can briefly detain someone if they have reasonable suspicion of criminal activity, but the detention must be limited and justified. Importantly, not every police or federal encounter is a detention. There are 3 types of encounters: consensual encounters, brief investigative detentions, and arrests. In a consensual encounter, you are legally free to leave at any time. Agents often conduct extended questioning in what is legally a consensual encounter, meaning you could have walked away at any point. The Supreme Court in Florida v. Bostick, decided in 1991, held that the test for whether a person is seized is whether a reasonable person would feel free to decline the officer's requests or otherwise terminate the encounter. If agents haven't formally detained you, you may be free to go. The evidence problem. If you stand there for 45 minutes answering questions without ever asking whether you can leave, the entire encounter looks voluntary. Anything you said during those 45 minutes comes in without challenge. But if you ask whether you're free to leave and the agent says yes, and you leave, the encounter ends with nothing usable. The correct move. After invoking your right to remain silent and refusing consent to search, say the 4th phrase. Am I free to leave? Ask it calmly and directly. If the answer is yes, leave immediately and without further conversation. Do not ask follow-up questions. Do not explain where you're going. Leave. If the agent says no, you are now being detained. At that point, say, I am being detained against my will, and I want to speak to a lawyer immediately. Document how long the detention lasts. That information is critical for any future legal challenge. Why it works. This forces the agent into a legal declaration. Either you are free to go, in which case the encounter ends, or you are being detained, in which case the agent must have reasonable suspicion to justify it. If they cannot articulate that suspicion, the detention is unlawful. Your attorney can use that later. Bottom line, always ask, am I free to leave after invoking your rights? If yes, leave. If no, demand a lawyer immediately. Mistake 5. Signing documents without legal counsel. The mistake. You've been detained, agents hand you paperwork. Just sign here, it's routine. You sign. You have just potentially agreed to voluntary departure, waived your right to a hearing before an immigration judge, or stipulated to facts you did not fully understand. A signature on an immigration document is not routine. It can be permanent. The scenario. An agent pushes a form toward you. It's titled in English. Maybe it's a voluntary departure form. Maybe it's a stipulated removal order. You don't speak English fluently, or you're too frightened to read carefully. The agent says it's standard. You sign. Weeks later, you learn you waived your right to appear before an immigration judge. You forfeited any chance of making your case. You signed it away in under 30 seconds. Why people do it? People are frightened. They think signing will get them released faster. They trust that agents are explaining documents correctly. They don't know that signing certain ICE forms can trigger immediate removal without a court hearing, a legally catastrophic outcome that may be impossible to reverse. The legal reality. In immigration proceedings, you have a right to a hearing before an immigration judge. The Supreme Court recognized in Fong Yu Ting versus United States, 1893, and later cases, that deportation is a severe consequence requiring procedural due process. Voluntary departure and stipulated removal are legal mechanisms by which a person can waive court proceedings, but only if the waiver is knowing and voluntary. The ACLU and the National Immigration Law Center are clear. Do not sign any document without speaking to a lawyer first. You have the right to refuse. You have the right to consult counsel before signing anything. The evidence problem. A signed document is an official record. Immigration courts treat your signature as evidence of informed consent. Challenging a signed waiver is extraordinarily difficult after the fact. The correct move. When handed any document, say the fifth phrase. I will not sign anything without a lawyer. Say it clearly. Repeat it. Agents may insist it's routine. They may say it doesn't matter. They may increase pressure. Hold firm. You have the legal right to refuse to sign. You have the right to consult an attorney before signing any document that affects your immigration status. This is not obstruction. This is a constitutional right. Why it works. This puts the legal process on pause until you have representation. A lawyer can identify what you're being asked to sign, explain the consequences, and advise you on whether signing is in your interest. Without that, you're being asked to make a permanent legal decision under extreme pressure and fear, exactly the conditions under which people sign things they regret. Bottom line, never sign any immigration document without first speaking to a lawyer. The answer to every document pushed toward you is, I will not sign anything without a lawyer. The 5 phrases. Memorize these. Here is the complete system. 5 phrases. They work together. Each one builds on the last. Phrase 1. Do you have a judicial warrant? Say this before opening any door. Forces agents to establish legal authority before entry. Phrase 2. I am exercising my right to remain silent. Say this before answering any question about your status, origin, or documentation. Explicitly invokes Fifth Amendment protection under Salinas versus Texas. Phrase 3. I do not consent to this search. Say this every time a search is proposed. Without your consent, agents need a judicial warrant they almost certainly don't have. Phrase 4. Am I free to leave? Say this when the questioning lingers and no formal detention has been declared. If yes, leave. If no, demand a lawyer immediately. Phrase 5. I will not sign anything without a lawyer. Say this when any document appears. One signature can waive rights you can never recover. Print these out. Put them somewhere accessible. Practice them until they feel natural. Because in the moment, when agents are at your door and your heart is racing, you will not have time to think. You need these phrases automatic. One more thing. These phrases are not magic words that make agents disappear. They are constitutional anchors. They create a legal record. They force agents to operate within the bounds of their authority. They preserve your rights for any proceeding that follows. And they work regardless of immigration status because the Fourth and Fifth Amendments cover all persons in the United States, not just citizens. The Constitution applies right now, at your door, in the moment that matters most. This is educational content only, not legal advice. For guidance specific to your situation, consult a qualified immigration attorney in your state. If this helped you understand your rights, share it with everyone you know. Your neighbor, your coworker, your family. Everyone in this country deserves to know these phrases before they ever need them. Stay informed, stay calm, and know your rights.